Welcome, everyone, to the 2021 Howard Lichtenstein Distinguished Lecture in Legal Ethics. We are delighted to welcome Professor Susan Bandas. This lecture is a long time in the making because more than 2 years ago, I spoke with Professor Bandas about coming here. She was happy to do so, but of course, COVID got in the way. And thank you, Professor Bandas, for her fortitude and her dedication in agreeing to come this year and having waited 2 years to do so. The Lichtenstein Lecture is an important moment for us to reflect upon cutting-edge issues in the law. Howard Lichtenstein, who was an employment lawyer with an abiding interest in legal ethics, decided to dedicate this lecture some years ago, and he has sponsored this yearly lecture. This year, the impact of COVID, the concern about well-being of our students and faculty, concerns about future careers, the future profession, and our country has caused a great deal of anxiety. Some people would say they were in a state of anxiety. Years caused wide-ranging emotions, whether it be the state of our democracy, the death of George Floyd, voting rights, the Supreme Court. So what could be more important this year than to talk about emotion and law? To say we're fortunate to have Professor Bandas with us is quite an understatement because she is primarily responsible for the development of what now is a field, an entire field looking at the role of emotion and law. I'll tell you a bit about her background in a moment, but I wanted to start by acknowledging for those of us, particularly women, who came into the profession in the 70s, how significant her work has been and continues to be. There were few women in the law in the 70s. Women were thought to be not as serious, too emotional, many other stereotypes that persist today in some measure. So the very idea that in that era, a woman academic, of which there were few, could laser focus on the role of emotion in law and create an academic field exploring that role, it was courageous, it was bold, and it was inspiring. Professor Bandas has served as that inspiration to now generations of law students, professors, and academics as she works in an interdisciplinary fashion, learning cognitive science, branches of psychology, and sociology. Her recent work, Thinking and Feeling Like a Lawyer, was published in the Fordham Law Review. She'll be teaching about that article this afternoon in one of our classes. I commend it to you. So let me tell you a little bit about her. She graduated in 1976 from the University of Michigan Law School, then went to work at the Appellate Defender organization as an appellate defender. She then went to the A.C.L.U, where she was staff counsel, and joined the DePaul University faculty in 1984. She was named Distinguished Professor, Research Professor in 2003, and the Centennial Distinguished Professor in 2012. She's a nationally recognized scholar in federal jurisdiction, in criminal procedure. She's written more than 70 articles and is among the top 20 most cited law professors in the field of criminal law and procedure. Her work appears in many law journals as well as interdisciplinary journals, and her book, which is entitled The Passions of Law, was published by NYU Press in 2000 and is called the, quote, groundbreaking anthology and a high watermark of the emerging discipline of the study of law and emotion. Professor Bandas has been a visiting professor at a number of universities in this country, and she was a Fulbright Scholar in Sweden and a distinguished visiting scholar at the University of New South Wales. Professor Bandas, we are so looking forward to your talk today. Thank you so much for joining us. Welcome.
I'm going to take you back to the early days of law school, which are intense in a way that's hard to explain to those who haven't experienced them.
Is the Zoom audio working now?
We don't know, we think so.
Working now? Okay.
Working now. Okay, we see it up here. Okay, wonderful. Thank you. It's not just that law school is a new form of training or education. It's more like an induction into a new order, kind of a secret society. There are rules. And especially if you don't come from a long line of lawyers, many of those rules are not laid out for you. They're implicit. They're waiting to be discovered. Every culture and subculture has these implicit rules, and they can work like landmines. You learn they exist only if you accidentally trip over them. It took me years to go back and examine some of the rules that are so ingrained that they too often go without saying. And the rules I want to talk about today are the ones you are told you need to master to learn to think like a lawyer. What I learned when I came to law school was that to be rigorous, tough, lawyer-like, all the things that I aspired to be, I would need to put emotion aside. Where exactly I was to put it was never specified, but it clearly did not belong in the law school classroom. I sometimes date my first awareness of these rules to a day in contracts class pretty early in first semester. We were discussing the Peavy House case. Do I have any contracts professors here? Okay. A family had their mountaintop home wrongly destroyed when a coal company strip mined the mountain. What were the damages? To replace the home would cost more than $20,000, which, believe it or not, was a fortune in that time and place. But the market value of their land, which was now on a strip mined mountain, was $300. And that was the amount the court awarded. In class, this was presented as a simple doctrinal choice between replacement value and market value. And the court determined that giving the homeowners their paltry sum of $300 at market value was the correct result. Somehow I already had figured out that it was not okay to express my anger at the holding out loud, and that it didn't even belong in my official class notes. In the margin of the book, I wrote a slightly profane phrase followed by an exclamation point. I was learning the lesson. Voicing anger or outrage would mark me as emotional, foolishly sentimental, and incapable of the rigorous task of thinking like a lawyer. Law communicates this lesson about emotion in multiple ways, and I have a few examples for you. First, this is, you don't have to read all the writing, just the yellow part. This is the Federal Rules of Evidence, Rule 403, where the advisory committee defines unfair prejudice, which means an undue tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. So emotion and prejudice are equated there. I also Googled looking for handy advice on what it meant to think like a lawyer, and here's a pretty standard piece of advice from something you can purchase online. Avoid emotional entanglement. There's a reason you might say you were blinded by anger or another emotion. Feelings aren't rational, and they keep you from seeing facts that might be important to solving a problem. Emotions and sentiment can cause you to become attached to details that bear little or no importance to the outcome of the situation. I'm going to come back to the DeShaney case and talk about it in a fair amount of detail later, but I just wanted to, this is the Supreme Court case that I'm going to be talking about, and I just wanted to show you the highlighted language in which the Supreme Court, acknowledges that judges, like other humans, are moved by natural sympathy, but then immediately warns you that this is not an impulse. Sympathy is not an impulse that judges can yield to or should. They cannot let compassion or empathy affect their decisions. And finally, I attended a lecture by a very well-known law professor who's a behavioral law and economist. And he used this comparison to explain how lawyers ought to think. Like the Vulcan, Mr. Spock, who has no emotions, the alternative being Homer Simpson. Let's go. Okay. Law school first year especially is a fraught time. Students are asked to open themselves up to a new way of thinking, and they're warned that they need to put aside certain familiar ways of understanding the world. Thinking like a lawyer means accepting that some things that seemed important will turn out to be irrelevant, and that some things that seem tangential will turn out to be important. And that's disorienting. There's no way around that. And the thing is, thinking like a lawyer is a valuable framework. It does give you essential tools that will help you excel at lawyering. But when it gets dangerous is when it starts to deprive you of critical tools that you will need to survive and thrive. Your moral compass, your intuitive sense, your empathy, your compassion, your anger, and your moral outrage. The challenge is to hold on to your moral and ethical compass in the face of all this disorientation. sometimes even in the face of contrary instructions by those who seem like they know better. As I hope to demonstrate to you today, one of the legal system's most cherished beliefs, its belief that emotion is the enemy of reason, is just plain wrong. It's unsupported by the evidence, and it leads to all sorts of deleterious consequences. It leads to bad consequences for the people who practice law, for people who are affected by law, which of course is all of us, and I will argue for the integrity of the law itself. Even those who worry about mindfulness and work-life balance too often believe that rigorous legal analysis demands putting emotion aside, and that any spillover effect on our mental health is just an unfortunate collateral consequence. But my theme today, and the underlying theme of the whole field of law and emotion, is that rigorous legal analysis is harmed when it tries and always fails to put emotion aside. Because what is law? Law is a system of rules and norms that's designed to predict and regulate human behavior. It can't do that very well if it's wrong about the major driver of human behavior, which is emotion. So in the 25 years that I've been writing on this topic, one of the things I've been most struck by is how resistant our profession is to considering evidence that contradicts its cherished view of rationality. Or to put it in another way, the law seems awfully emotionally invested in its outmoded, discredited view of emotion. Of course, it isn't only law that has this misconception about emotion. It's baked into our language. Consider the verbs we attach. Oh, there we go. Okay, I guess I don't have a slide for that, sorry. Consider the verbs we attach to the noun emotion. We give into it. We are overcome by it. We are blinded by it. It overtakes us. This long-held belief that emotion short-circuits reasoning sounds like it must be based on some kind of evidence, especially because the legal profession seems so darn sure it's true. But in fact, it's contradicted by a growing consensus in every field that studies the dynamics of decision-making: neuroscience, philosophy, psychology, sociology, criminology, anthropology, organization theory. None of those fields say that emotion always steers us in the right direction. Of course, it does not. But they do conclude that it's not the enemy of reason. That's an essential part of the reasoning process. So this is Antonio Damasio, a very well-known neuroscientist. Even before science obtained powerful neuroimaging tools like CAT scans and PET scans, it had evidence from people who had undergone traumatic brain injuries that left them unable to feel, but left all their other reasoning tools intact. Antonio Damasio wrote about subjects like Elliot. Elliot was in an accident that rendered him unable to feel emotions, even as it left his IQ unchanged. He lost the ability to make good decisions, leaving his personal and professional life in ruins. He kept amassing information, making lists of pros and cons, but he could never determine which information mattered to him. So let's talk about what emotion is, and also about what law thinks emotion is, because I'm not actually here to find with you an overarching correct definition for emotion, because I'm a lawyer, I'm not a philosopher. My interest is in reforming the legal system. Law isn't just a system of thought. It's a system that leads to consequences, including life, loss of life, loss of liberty, and loss of property. So the real question we need to be concerned with as lawyers is a very practical question. Once we've established that emotion is part of law and isn't going away, then we can move on to a more productive discussion. Which emotions in which legal contexts? How can we use what we know to achieve fairer and more equal and equitable results? So that's basically the framework here. Which emotion in which legal context? Let's look at the dynamics that we can learn about the various emotions. Like, we can debate the goals of the legal proceeding. We may not agree on them. And then we can talk about what legal reforms will permit us to promote the right emotions in the right context. I'm going to talk about a number of emotions today: remorse, compassion, and empathy, to name a few. But I'm going to focus especially on anger. Because anger or moral outrage, which Professor Yarshevsky has also written about, is the emotion I tried to put aside in contracts that day when we studied the Peavy House case and many, many days after that. And there's no question that anger has its downsides. One of the roles of the legal system, we might all agree, is to put itself between litigants and their raw, unfiltered anger, to introduce safeguards like fairness and equal treatment. But it's also anger that fueled much of my civil rights career. Anger at government overreaching, anger at the way the vulnerable were treated, anger at injustice and unequal access to justice. It was anger that inspired me to write most of my law review articles and every op-ed I've ever written. So I want to spend some time talking about anger and its role in the legal system, and that will allow me to illustrate the importance of context, the idea that we shouldn't really be making sweeping generalizations about emotion in law or about any particular emotion in law. Context matters. Okay, so what does the legal field think emotions are? It thinks they are quick flashes of intense feeling that derail rational thought. They're unpredictable, they're untamable, and of course it follows that we can't study them and we can't educate them. Now let's look at what the sciences and social sciences, the emerging consensus among these fields about what emotion is. As neuroscientists have now shown us with fancy colored pictures of the brain has no emotion center. There is no left brain, right brain split. That's one of those zombie ideas that just won't die despite being thoroughly discredited. All right, that's a lot of writing. But the characteristics of emotion. Emotions are processes. They're not things in the world. They're distributed all throughout the brain. And they assist us in reacting to the stimuli that are constantly bombarding us. They influence the way we screen and categorize information. They influence our evaluations of the intentions and credibility of others, something that law has to do every day. They help us determine what we remember and how we form our memories into narratives. Most important, I think, emotions drive us to care about the outcome of our decision making. They help us decide what's important and valuable. They motivate us to take action or refrain from taking action on the situations that we encounter. So what this means is that emotion is not optional. It's not a detour. It's not just a poor substitute for reasoned deliberation. It's an essential part of the reasoning process. There's a common misconception, popular among law and economics scholars, for example, that emotion might provide a shortcut sometimes, but it's always a second best path. Actually, thinking fast and slow. They don't actually offer you anything you can't get from slow reasoning. That's the misconception, but that's not correct. Emotion does give you access to certain features of decision-making that are not provided by deliberation. The vividness of certain information, the priority of this information in your memory, and its ability to motivate you to act, and finally, its ability to help you understand and empathize with other people's viewpoints. As one cognitive scientist argues, only by feeling emotions are we capable of recognizing the value or significance of anything, whatever. And emotion is educable. If we can identify and evaluate our empathy, our compassion, our moral outrage, then we can evaluate them and see whether they are leading us in a good direction in law or elsewhere. If what we do instead is put emotion aside, as we are always instructed to do, what happens then? It doesn't go away. What happens is that we lose the ability to evaluate it, and it continues to act, continues to influence us, but now below the radar. So let's examine why this matters to law. First thing that might jump out at you in light of the definitions above is that if I'm right about what emotion is, it must be everywhere in law. And the first sentence of my first book was, emotion pervades the law, because it is everywhere. But sometimes it's obvious and sometimes it's invisible. So if I were to say to you, can you think of examples of emotion in law? I'm guessing that some examples would come to your minds right away. A homicide is less capable if it's done in the, less culpable if it's done in the heat of passion. There's an exception to the hearsay rule for excited utterances. Rules about police excessive force depend on whether the officer was acting in reasonable fear for his or her safety. Tort law permits recovery for the intentional infliction of emotional distress. These are all examples of the law actually acknowledging emotion, though not necessarily getting it right. For example, it turns out there's no evidence that an excited utterance is more reliable than a calm utterance. Unless we assume that all this getting it wrong is going on only in the state courts and state legislatures, let's look at an example of the Supreme Court acknowledging emotion and getting it wrong. This is Gonzalez versus Carhart, the what's commonly known as the partial birth abortion case, where former Justice Kennedy says, it is self-evident that a mother who comes to regret her choice to abort must struggle with grief more anguished and sorrow more profound when she learns what she did not know before the event. Everyone who has actually conducted empirical evidence on abortion and regret has said it is not only not self-evident, but it is completely contrary to the weight of the evidence that he just got it wrong. But these are just a few examples of the law acknowledging emotion. What I'm here to say is that even more dangerous are the places where law doesn't acknowledge it. One of the most powerful examples of this phenomenon that I want to talk to you about is the question of remorse. Talk about remorses all around us, just constantly. People say awful things in public and we wonder whether they were remorseful about it. We assume remorse matters a lot. We assume that sexual predators and other wrongdoers should express it. We assume that their remorse should be sincere, and we assume that we can tell sincerity from play acting. These assumptions are very much alive in the legal system. There's substantial empirical evidence, for example, that it plays a role in criminal sentencing decisions. The Capital Jury Project, which has interviewed scores and scores of people who've served on capital juries, found that it was either one of the three most important factors or the most important factor determining whether a capital jury sentenced somebody to death or not, whether they thought that person was remorseful. Now, what you need to understand about this, those of you who haven't studied capital punishment, is that almost never does a capital defendant testify. So what we're actually talking about here is a jury sitting, watching a capital defendant sitting silently at the witness table while the defendant listens to the evidence, watches the evidence unfold. And the jury watches the facial expression and body language of the defendant and determines whether he was remorseful. Now, the other thing to understand about this is that nobody tells them to do this. They get no instruction on it. The prosecutor might possibly find a way of saying, look, he has expressed no remorse. We can talk about whether that is legally okay or not, but nobody sends them into the jury room with instructions. They go in there and they just know that that's what they should care about and that they are capable of evaluating it. So this is Tsarnaev, who's back in the news now because this case is back before the Supreme Court. This is the convicted of the Boston Marathon bombing. And this is a picture from Slate magazine, journalist named Seth Stevenson. Every day he would go and come back with a artist sketch like this and write, Tsarnaev is completely unremorseful. He was fiddling with his beard. He was tapping his toes. He was leaning back in his chair. The parade of victims doesn't seem to bother him very much. So quick story about that. I finally couldn't stand it anymore. I sent Seth Stevenson one of my articles, and which I'm about to talk to you about. And I said, there is no evidence whatsoever that you can tell remorse from watching somebody's facial expression and body language. And the next day he wrote another article saying, Professor Susan Bandy sent me this article saying this and this, but I know it when I see it. So, bottom line, the criminal justice system has been sentencing people to death based on their facial expression and body language. I got curious, what's the evidence about this? And it turns out that psychologists have been building a whole thriving subfield about emotion and facial expression. So I delved into the findings of that field of study. it turns out there's, as I said to Seth Stevenson, absolutely no evidence that remorse can be read from facial expression or body language. To compound the problem, there is evidence that factors like race, juvenile status, and mental disability or use of psychotropic drugs do affect these evaluations. So age, there's a whole spate of young children killing somebody and the judge determining they are remorseless predators because they do not have the appropriate facial expression. And there's lots of evidence about why it is that an 11-year-old or 12-year-old might not yet feel remorse or might feel it and be unable to show it in the way that the judge recognizes. Mental disability, I'll get to cultural differences in a minute, race, gender, and, by the way, people who are actually innocent and therefore don't look remorseful. This becomes a real problem too. The cultural differences, as you can imagine, there are different cultural norms about how remorse is expressed. For example, different implicit rules about eye contact. So, first point, that's an important lesson about emotion. Emotion, according to the legal system, is kind of a thing in the world that has specific parameters. We just have to recognize it. Is it remorse or is it not? But in fact, evaluating emotion involves at least two people, not only the subject, but also the evaluator. And the evaluator will have her own notions about how emotions ought to be expressed. She'll have her own notions about what remorse ought to look like. So in one study of judges in Connecticut, for example, the majority of judges surveyed were sure they could tell whether a defendant was remorseful just by observing facial expression and body language. When asked what they looked for, half of those judges said that direct eye contact showed arrogance and lack of remorse, and the other half said that direct eye contact was strong evidence of remorse. So there is no, if I had time, I could talk about the fact that the judges also get to talk to the defendants, and that doesn't really help either, because judges have their own little lists of magic words that they want to hear the defendant say. Last point about remorse. Why do we care about it? Many judges and jurors seem to care about it because they are sure that it predicts lack of recidivism. It predicts that a defendant will be less likely to commit another crime. But in fact, there is no good evidence that that is true. Indeed, we are familiar with domestic abusers who feel genuine remorse, probably, apologize sincerely and profusely, and then do the same thing again. So that's the consequence when we ignore emotion. People are sentenced to death based on erroneous beliefs. People are given a pass based on erroneous beliefs. If we acknowledged that remorse was playing this role, rather than insisting that law operate as an emotionless sphere, we could have a constructive discussion about how to fix the problem. Jury instructions, perhaps, expert witnesses, perhaps, judicial training, perhaps. All these solutions could be on the table. But first we have to acknowledge that the emotion is playing a role. So people tend to think of law as having little pockets of emotion, me included for a long time, without actually questioning the whole emotion-reason dichotomy. I practice criminal law. I practice civil rights law. These are all emotionally fraught and challenging subjects. I never really, for a long time, examined whether putting emotion aside was necessary, whether that actually was part of being a lawyer. It took me years to decide or to understand how damaging this was to me and to all my colleagues. So it's wonderful news that the discussion about lawyer well-being is finally getting some traction these days. But what I'm here to say is that the question of lawyer well-being isn't only about individual lawyers. It isn't only about mindfulness and work-life balance. That's just a piece of a larger problem. The law's insistence on regarding emotion as weak, as suspect, as unwelcome. And there's a gendered aspect to this that Ellen talked about, which we could certainly talk about as well. When I began teaching, I wrote about criminal procedure, civil rights, federal courts. And in my 5th year of teaching, the Supreme Court handed down 2 opinions, both written by Justice Rehnquist. The first was the DeShaney opinion. There, the court held 5-4 that young Joshua DeShaney, here he is, had no constitutional claim against the state of Wisconsin for its persistent failure to protect him from his abusive father, despite their knowledge of the ongoing abuse. The opinion caused a sensation, partly because it acknowledged emotion. As I showed you earlier, what it said about emotion was that compassion for Joshua is understandable, but precisely the thing that the judges had to avoid. It caused another sensation when Justice Brennan wrote an article asserting that, in fact, compassion and other passions should play a role in legal analysis. Legal scholars were outraged. One declared that Justice Brennan wanted to undermine the very foundations of the rule of law. This struggle about the role of compassion in that case still resonates today because it was a struggle about what conception of freedom the Constitution protects. Does due process of law protect only our right to be free from government interference, or does it give government some affirmative duties to care for its citizens? Is freedom all about being left alone to do whatever you want? Or does freedom also mean protecting our ability to live safely and securely? These lofty philosophical questions are also life and death practical questions, as our current debate about masking and vaccination mandates illustrates. And that debate shows us something important about emotion. It's not just one side of the autonomy and freedom debate that relies on emotion. Both sides are making claims about who is worthy of empathy and compassion, for example. The DeShaney case wasn't really a debate about whether emotion should play a role in decision-making. The opinion of the majority didn't avoid emotion, it just avoided acknowledging it. The majority, while denying empathy to Joshua, expressed empathy for government officials who are legitimately between a rock and a hard place when deciding whether to remove children from abusive families. But they saw a certain type of compassion as weak and lacking rigor and therefore irrelevant. They didn't examine the notion or the origins of the notion that the government's role is just to step aside and let us sink or swim on our own. They didn't see their argument as having emotional and ideological aspects to it. And so one more thing about that. A hallmark of the majority opinion was its insistence that the 5 majority judges were just following the law as written and had no other choice in the matter. The result was, in their words, undeniably tragic, but the justices had to do what the law said they had to do. So we could spend a good amount of time talking about the emotional value to judges of believing that they are just following the law and not making hard choices with life or death consequences. The brilliant legal scholar Robert Cover wrote about this coping mechanism when he wrote about the anti-slavery judges pre-Civil War who enforced the Fugitive Slave Act. The Fugitive Slave Act, which permitted people to capture freed slaves in free territory and return them to their masters in slave states. And the judges who were abolitionists but who upheld the Fugitive Slave Act said, we feel awful, but we have no choice. Cover talked about this, and Justice Brennan cited this when he critiqued the DeShaney opinion. So DeShaney was a fascinating case, and when I first read it, I actually thought all the opinions made persuasive arguments, but then I got thrown for a loop. This is my origin story of how I got into law and emotion. That same term, Justice Rehnquist wrote another opinion in another 5-4 case, Payne versus Tennessee. In that case, the judge's majority opinion permitted the family members of murder victims to tell a capital jury about the emotional impact of the loss of the defendant on his family. It permitted the family to describe what was special about the victim and why they missed the victim. The court upheld the statements, and they are now the law everywhere in the United States. At that point, having read Payne and DeShaney, I thought I was just confused. I thought I was missing something important. I said, I'm going to put aside 2 hours and do a Westlaw search on the role of compassion in the law so I can understand what's happening here. So here I am 25 years later to tell you that it wasn't in Westlaw, and the court still hasn't done it. So let's examine the empirical claims about how emotions affect decision-making. One of the misconceptions about emotion is that it can't be studied, but there is, in fact, a vast wealth of data about how various emotions affect legal decision-making. And let's make it concrete and specific. We're going to find that whether emotion helps or hinders will depend. Which emotions, which proceedings, what are the goals of the proceedings, judge or jury, civil or criminal, trial or mediation. Let's come back to anger. So what would happen if we could imagine, or if we could acknowledge that anger plays various roles in law? We might ask, what have the fields that studied anger learned about it? What are anger's strengths and weaknesses? What are the goals of the legal system? And does anger help them or hinder them? So in the contract example I gave you, I was angry. My anger, though I didn't understand at the time, actually contained valuable information. It helped me perceive an injustice. The philosophical debate about the moral content of anger dates back at least to Aristotle. More recently, philosopher Jesse Prinz observed, anger is a necessary component of morality. If we relinquish anger, we lose our moral sense. Philosopher Agnes Callard similarly says, anger arises not only from our understanding of moral principles, but from our attachment to those principles. It's not purely cognitive. Our desire to do what's right, to make law more inclusive and fair, is triggered not just by a violation of abstract principles that we admire, but by a visceral sense that real people are being harmed. So anger can lead us astray, right? There's no question about that. Anger can lead us astray, yes? On the other hand, anger fuels protests against racial segregation, Black Lives Matter, anger, depending on what your own ideological commitments are. And I'm not here to tell you what they should be, but anger can help you perceive them and act on them. Brittany Cooper wrote a wonderful book called Eloquent Rage. A Black feminist discovers her superpower. She makes a distinction there between eloquent rage and righteous rage. She notes that when rage is unchecked, when people don't do the emotion work to sort through their reactions, they can get the target of the rage wrong, but the rage itself is eloquent. And acknowledging it permits the crucial next step, sitting with it, sitting with your anger, evaluating your anger, articulating it. See if you can articulate it in words that can then be evaluated and reasoned with. It's not just an ephemeral set of impulses. It can be studied, it can be debated, but it's a signal. Now, let's look at one of the downsides of anger. One of my valued co-authors is the brilliant Jessica Salerno, a psychologist who, back when she was a student, took my seminar on law and emotion, now runs a lab at Arizona State that does experiments on how emotion affects legal decision-making. One of the things she's found is that anger is a mixed bag. It moves people to action, but it does it in part by encouraging deliberative shortcuts. So she and I have written together about gruesome photos and victim impact statements. Rule 403. You can't bring in evidence whose prejudicial effect outweighs its probative value. So how do we think about graphic photos of dead bodies at crime scenes or autopsies? If a medical examiner can testify about the path of the bullet, the blood splatter, the condition of the body, why do we need a photo? We argue that emotion has a lot to do with not only what might make the photos prejudicial, but also what makes them probative in the first place. What is it about photos that makes them speak to us in a different way than medical examiner testimony? But here's the part I find most fascinating. We found that vivid color photos, and there was a difference between black and white and color, by the way, that vivid color photos made jurors angry and disgusted. And maybe that's not a problem. Maybe you could argue that the photo is, after all, just showing you close up what the defendant is accused of doing to the victim, and that's an appropriate thing to be angry about. I'm not saying that's the correct argument, but it's certainly a reasonable argument. But here's the problem with anger here. The anger the jurors felt didn't just affect their evaluations of the photo evidence. It damaged their ability to evaluate the other evidence in the case. They became so angry they wanted to punish the defendant, and they started discounting any evidence that contradicted that impulse. They engaged in what we call a biased information search. So if our goal here, and it should be, is careful evaluation of all the evidence, then this is a problem, right? I'm going to kind of, let's see. No, I think I can. I just want to briefly mention one other thing about Salerno's work, because I can't go through this whole talk without talking about gender at all. This is issue of how race and gender affect our evaluations of credibility and what kinds of emotions people are allowed to feel. I'm just putting up Serena Williams and Brett Kavanaugh without comment. She found, she did a study that got a lot of play. She looked back at the kind of, if you've seen 12 Angry Men and or read the play about Henry Fonda, the upright 12th juror, the holdout who just wants to talk about the case and ultimately gets everybody to change from guilty to a not guilty verdict. Salerno wanted to know how this would work if Henry Fonda had been a woman. And what she found was that when men express anger, when men holdout jurors express anger, it made them seem commanding and authoritative. Angry women were more likely to be seen as hysterical, overly emotional, and untrustworthy. In later research, she and her co-authors found that this is also true. It works much better for white men than for black men. So as you can imagine, there's lots more to say about this kind of finding for credibility determinations across the board, and also for how jurors view lawyers in the courtroom. She did some interesting work on that too, but I don't have time to get into that now. My point here is not to have you decode this, but just really to show you that there's a lot of work going on, a lot of interesting, rigorous work going on studying how emotion affects decision-making. It can be done. Okay, so I'm going to conclude. One significant difference between law and many other professions is the way that law, in this case, like the military and like law enforcement, equates toughness and stoicism with competence. In those fields and our field, showing vulnerability is viewed as a sign of weakness. It can wreak havoc on reputations and careers. I mean, you've probably seen this. Lawyers have the highest rate of major depressive disorder of any occupational group, much higher than doctors, among the highest rates of alcoholism. As I've argued elsewhere about the field of law, there may be no other profession whose practitioners are required to deal with so much pain, with so little support and guidance. What's most pernicious about the plight of our profession is how we equate rational and rigorous thought with a lack of emotional awareness. The result is that we lose information and coping skills that we need, both to practice law and to lead healthy, well-integrated lives. It's harmful and also impossible to separate law, morality, emotion, and ethics into neat, separate little quadrants. What are the consequences of trying? We see them all around us: burnout, isolation, unacknowledged psychic pain, impaired ethical judgment. These consequences are on nobody's list of desired outcomes. So why would we choose an approach that cuts students and lawyers off from fruitful sources of knowledge and wisdom, and from the excitement that drew them to law in the first place? My contribution to the debate is to suggest that law's deeply rooted attachment to a particular notion of rationality is a major culprit. It's kind of malpractice, really, to hang on to this discredited emotion-cognition split. And certainly it's not rational. Emotion should be embraced as a species of knowledge, one that is analyzable and educable like any other. The effort to banish emotion from the legal conversation leads to not banishing it, but to below the radar choices, blocking in opportunities to reform legal institutions in light of the best available knowledge. And it's contributed to the psychological distress of generations of lawyers. So I'll just conclude by saying, let's do better. Thank you.
That's terrific and full of information. She teaches a course, right? An entire course on law and emotion. And hopefully you can see why it's so rich and what we could explore. So let's take a few questions or comments. Anybody want to jump into the foray here?
Love to answer a question or two.
So I'll start. So you've been doing this for 25 years. We have more women in the profession, although still not at the heights. We have more people of color. It's gotten more diverse. Have you seen any difference in terms of the focus upon acknowledging the role of emotion?
That's a great question. I think so. I mean, certainly, if I say the old Kingsfield paradigm, will you even know what I mean? The paper chase? Happy if you don't. But so the old paradigm of the mean, gruff, Socratic professor, I think has pretty much gone by the wayside. I think legal education has come a long way since I was in law school. And the fact that when I was in law school, I didn't have a single woman or professor of color teaching us was huge. And so in those regards alone, I think it's huge. And the other thing I would say about it is that part of what I'm describing here, the way that law doesn't want to learn from psychology, philosophy, sociology, and all these other fields, I think that's a general problem. It's not only a problem with rejecting emotion, it's a problem of law thinking that you can find all the answers to legal questions just by looking at law and not looking elsewhere. And I think we've gotten better. I mean, we've got environmental science, we've got lots of fields that, have started learning from other disciplines. So that kind of wall has been coming down. I do contend that there's something about emotion that that's different. Lawyers who can imagine looking at certainly economics, but environmental law or other fields are still not so happy about emotion. There is something about it that is extremely threatening to some core self-conception. And whether that's gotten better, I'd have to think about that a little more.
Questions? Yes. We
A
need.
lawyer, you're representing somebody, you're going to talk to a client about a judge, how to help the judge emotionally, how they're going to respond. You've studied them. And what about jury consultants? Aren't they? I mean, they've been around for a long time, and they're only going to be talking to the lawyers about how to posture yourself to a jury about emotion. A lot of part of the practice.
So Professor Banis, can you repeat Professor Lane's
I'm going to
question?
repeat the question, and I hope I'll get it right. But the question is, I think I understand you to be saying, hasn't emotion really been in the mix all along? Because we have jury consultants who think about how jurors will emotionally react to the testimony, and also if your client is going to be appearing before a particular judge, you're going to talk to your client about that judge's own preferences. Is that a fair? Okay. Yeah. So, right. So, I mentioned earlier, I think that we all see little pockets of emotion. Like we can all come up with examples. The jury is the classic example, right? The sort of classic idea is that, well, the jury is a bunch of lay people. And so, they're not going to be living by the sort of rational rules that the rest of us in the legal profession live by. So yes, we're going to figure out, and some of the words that get used, we're going to figure out how to grandstand, how to showboat, how to persuade, and persuade takes on a kind of an almost illicit cast to it, right? Because we can't just talk to them about law. We have to find an emotional way to reach them. And that becomes portrayed often as because they're lay people, they don't know better. So, but you also raise judges, which is a very interesting point, right? And, I study judges a lot. We have a lot less empirical evidence on judges because judges, generally don't like to be studied. And because there is this kind of ideological purity that they wish to communicate about the fact that they are not emotional and that is not going to affect them. So that self-image has really become a bit of a problem here. The remorse example I gave earlier is a good way of responding to this or of explaining what I'm talking about here. Every judge has, if you have a record of it, his or her own preferences about how to sound remorseful. some of these studies are amazing. Like for this judge, don't say anything that could imply that anything was anyone else's fault. For that judge, be sure you acknowledge the pain that the victim was in. Really magic words, right? And so if you're a good lawyer, you are indeed going to do that. But that sets up a kind of caste system, really. There's certain information that's not available to everybody. And the problem is that the judges don't acknowledge it. It doesn't find its way into judicial opinions, right? It's not part of the law. It's sort of again, a below the radar discussion. Yeah, you want to follow up?
I just want to, so even when you take a more mundane topic like statutory interpretation, you have a statute that's clearly not clear on its face. I mean, in some ways it's clear. So one of the things that definitely, I taught this to one of the things you're going to try to do is figure out this guy. What are his empathies or empathies or sympathies? And to me, when you started by saying there's all these unwritten rules of this mysterious order and the family hasn't been, lawyers forever. I mean, I think most lawyers should understand that this is a big player in the business. Now, it may not be acknowledged in a big view, but take a Supreme Court decision on abortion. Take a Supreme, where it's an unclear position, where the Constitution not that you have to understand the emotion to sort of pick your best argument.
So 1 second, one of our problems here, I'm sorry that people online, we were not monitoring the chat. I'm sorry about the ceiling lights. We have a lot of questions from people online. They can't hear the follow-up comment of Professor Lane. So I don't know if you want to sort of summarize it and address it.
Do you want to take a question from online?
I was going to take one more.
Let me talk to you after,
No, you can go ahead.
and we'll take one from online.
Okay, so if we allow judicial emotion to determine outcome, aren't we inviting gender and racial disparity? Aren't we inviting a random system of law? What's the rule of law if we depend upon emotion for outcome? I know that there are other comments and questions. I'm sorry that we can't take them all.
Okay, no, let me just ask that question. So answer that question rather. So let me be clear that I am not in any way saying that emotion should determine outcome. That's the last thing I would say. I'm saying that emotion is one of the many variables and pieces of information that go into decision making, and that by recognizing it and acknowledging that it's already there. So I'm not saying we should bring it in. As in my remorse example, it's already happening. It's not something I'm advocating we begin with. It's something that's already happening and we are not studying. So my point is that if we acknowledge that it is part of decision making, then we can determine in what cases it is consistent with the rule of law, in what cases it does advance justice, and in what cases it is inconsistent with the rule of law or hinders justice. And in those latter cases, we can figure out how to improve things, but we can't do that until we acknowledge it.